third case on this morning's docket, case number 116810, State of Kansas v. Amber E. Burden.
Good morning, Your Honor. My name is Randall Hodgkinson, and I'm appearing today on behalf of Amber Burden. I request 3 minutes for rebuttal.
3 minutes is granted.
Your Honor, the procedural posture of this case is out of Sumner County, and Ms. Burden was prosecuted for possession of cocaine, possession of marijuana, and possession of drug paraphernalia, and convicted, not just prosecuted. One of the unusual sort of facts in the procedure in this case that will lead to the issue that you granted review on is even early on in this case during preliminary hearing, Ms. Burden started making indications that she did not want an attorney, although she was doing it in the context of not wanting to contract with the district judge and not recognizing the district of the jurisdiction of the district judge, and so forth. Because of the sort of unusual circumstances, the district judge ordered a competency evaluation, and for purposes of competency to stand trial, Ms. Burden was found to be, under that pretty low standard, competent to stand trial. And so the district judge then said that she would be allowed to represent herself, and then represented herself through the trial proceedings. We might talk about some more of those facts before and during the trial proceedings as part of our issue. But ultimately then Ms. Burden was convicted and sentenced for possession of cocaine and possession of marijuana. So I can choose to undergo a medical procedure, and I can knowingly and voluntarily choose to undergo a medical procedure, but I'm probably not competent to do that medical procedure on myself. There's a difference between being able and intelligently and voluntarily choosing to take a certain course of action and the ability, the capacity to actually do that course of action. And so that's our question here today, Your Honor, is Kansas going to recognize the gray area that is created in federal law through Indiana v. Edwards, this idea that there are some number of people that are competent to stand trial, but not competent to represent themselves at trial. And if Kansas does recognize that gray area, we're asking this court, I'm jumping ahead, the remedy we're asking is to require the district court to make an evaluation of whether Ms. Burden was competent to represent herself at trial.
In that gray area, it's an interesting question. Would your client, would Ms. Burden been able to enter a plea? Is there a difference between entering a plea and in terms of competence and understanding all the rights you're giving up, understanding you're waiving your right to an appeal, all the stuff that happens in a plea, and having to have that kind of comprehension and the comprehension that you need to represent yourself? And competent to stand trial? Does entering a plea enter into the gray area, or do you think? I know that's not the question before us, but what do you think?
But the answer we get from Indiana v. Edwards and from Godinez, from other prior United States Supreme Court precedent. And I was talking to my colleague ahead of time, and we remember when Indiana v. Edwards came out, and we thought, well, that's an easy win for a defendant in that case, because Godinez had said a client who has been found competent to stand trial is competent to make the decision to plead guilty. And so we thought, well, that's an easy win for Edwards, right? Because Godinez had already made this direct connection between these things. But the novel part, or the new thing from Indiana v. Edwards, is there is a difference, the United States Supreme Court says, in making the decision to enter a plea and waive rights and the ability to conduct yourself at a trial. So Indiana v. Edwards does stand for the exact proposition, Your Honor, that there is a difference. And so the law still today is, I think, under Godinez is still good law, that if you're competent to stand trial, you're competent to plead guilty, but you still may not be competent to represent yourself.
And then what fact? No, go ahead, Justice.
But the gray area that Indiana v. Edwards defined was still, and I quote the court, that the person suffered from severe mental illness to the point where they were not competent to conduct trial proceedings by themselves. So the key still is that there has to be a severe mental illness. What is the evidence in this case that your client suffered from a severe mental illness?
And so, to be clear, Your Honor, I'm not contesting today that we have proven that she's not competent to represent herself.
Okay.
That's not, I'm asking for a hearing where a judge makes competent findings on that question.
But is there a threshold before the judge has to do that? And does that threshold exist when the judge had an evaluation where the evaluator said, it is this evaluator's opinion that Ms. Burden has no significant impairment that is psychiatric in nature?
But that assessment was in relation to competency to stand trial.
But that's a very broad statement, that there's no impairment that's psychiatric in nature.
But it's all that evaluation was only for the purpose of determining whether she had any conditions that would impact her ability to assist her attorney or understand the proceedings. And that's a different question. So is there evidence in the record of a medical condition? No, because we've never had an evaluation with regard to does she have any medical conditions that would impair her ability to represent herself at trial? A separate question, as recognized by Indiana v. Edwards. So now, is there any evidence in this record that meets some threshold? Because I understand, Your Honor, for example, with even competency to stand trial, right? We're all sort of presumed competent to stand trial. There has to be some indicia that will even cause a district judge to have to maybe have a competency hearing. That's not the norm. The default is we're competent to stand trial, for example. And I would submit that the record in this case shows that there's indicia that Ms. Burden may not have been competent to represent herself. For example, even as the Court of Appeals recognized that Judge Mott, I think did a really good job here of trying to sort of help Ms. Burden a little bit. He said, and truthfully, based on our record, that you may have there seems to be a colorable issue regarding suppression in this case. You really should file a motion to suppress. And Ms. Burden said, yeah, I'm going to. And then she never does. That's an example of why didn't she? Is it because she couldn't sort of understand or because of mental illness, schizophrenia? I mean, I don't have any diagnosis because it's never been tested for this, but is that evidence that she said she was going to do it and then didn't do it repeatedly, even after the judge urged her to do it? Is that some evidence that maybe she's having difficulty with the capacity to do these things in court?
But on the capacity issue, it seems to me that it's your position, but I just want to clarify that this question of competency to represent oneself is coextensive with the right to represent oneself. So they're identical. Is that correct in your position? Because competency and a right are not necessarily conjoined.
Right.
But it seems to me that your argument is if you are not competent to represent yourself, you do not have a right to represent yourself.
Yes.
No. Okay.
Yes.
So,
that's what Indiana v. Edwards says. It says that the right to represent yourself is not absolute, and says that a state can put a limit on that, in particular in Indiana v. Edwards.
And I guess that, does that mean that the right does not extend past that point? Or does it just mean that the state can constrain it? And I'm not sure there's a difference between the two, but that's my question. Yeah.
Analytically, there might be a difference between the two. I mean, certainly, and the Court of Appeals decision sort of said, look, we're not in a place like Indiana v. Edwards because Ms. Burden was allowed to represent herself.
Right.
So
there was no constraint. And I guess that you see where I'm going with this.
Yeah.
Did Ms. Burden have a constitutional right to represent herself in this case?
Even if she wasn't competent?
Yeah.
That
Whatever under the facts of this case, is it your position that she did not have a constitutional right to represent herself?
My position in this case is Indiana v. Edwards says that there's a gray area where some people do not have a right to represent themselves. Those people being
it
people
says
who are
that
not.
they are not competent to represent themselves. And my question again is that the same as saying what you just recited, that they don't have a constitutional right?
For purposes of this case, yes.
Okay.
They can be
But
deprived
if-
of their right. They can be deprived of their right to represent themselves if the court has a hearing that determines they're not competent to do so. That's what you're saying.
Indiana v. Edwards says that if you are not competent to represent yourself, you do not have the right to represent yourself. I mean, that was your question, right?
Okay.
Right.
Yeah,
But if-
and I think that's right.
But it gives the state the right to recognize that. If Kansas had not yet previously recognized it, where does the right of your client to have, or I guess that's what you would argue, is that there was a duty on the part of the court to make a further inquiry? Where does that duty arise under Kansas law? Perhaps prospectively it could, but how does that affect your client?
Sure. And in fact, I think that's part of why we're here. I mean, I don't know that it's ever arisen before because we didn't have this gray area before. And before Indiana v. Edwards, I would have said, we don't have this question. If a person's competent to stand trial, they're competent. They absolutely have a right to
What
represent
if a
themselves.
state just says, thanks, Supreme Court, but no thanks?
Then and if you do, I mean, that may be a question because I understand the procedural posture of Indiana v. Edwards was such that Edwards was denied the right to represent himself. And so the question in Indiana v. Edwards was, are states permitted? And so if I understand your question
Yeah.
is, what if the state chooses not to take that invitation from the
Correct.
Supreme Court? Am I
Yes,
getting your
that's
question
the
right?
question.
I'm asking you to answer that question, first of all, in this case. That's
Well,
why
Mr.
we asked
Robinson,
for this.
I'm sorry to interrupt, but since you are saying perhaps there should have been a hearing, there should be a heightened standard, what factors, if you are correct, should support that heightened standard? What do you think should be determined? Because I'm thinking, as I look at this, that some of our arguments are what sovereign citizens make. You may disagree with them, but they are very passionate about self-representation. Should they be representing themselves? Not in my opinion, but they do have that right. So what should be considered, do you think, in this hearing, if a hearing were allowed?
I would look, and the United States Supreme Court didn't give us additional sort of guidance on the question.
I'm sorry, they didn't give us, I understand, but you're advocating for your client, so what should be considered? You've written a brief on it, you say it should happen. I'm asking you, as representing this person, what factors should be considered?
Sure. And the question that you can, the test that you can glean from Indiana v. Edwards, I think, is there because of any, and I don't remember if it said severe mental illness, but because of mental illness or impairment, is this person unable to do the basic tasks required for representing themselves? I believe that's the language that you can actually mine from Indiana v. Edwards. And that's the test that I would ask a district judge to apply if this court would remand it for that test.
Regardless of legal merit, because it obviously we can't rely on their inability to make a meritorious argument, because frankly, there are lawyers who have that inability as well, right? So
Some of us.
it's not about legal merit. It's not about being able to practice in the way that we hope that we practice. It's about standing up and making an argument or filing a motion to suppress when the judge keeps telling you that you.
It's about whether, on a proper evaluation, whether a person has mental illness or impairments of some sort that sort of prevent them from doing the things of court. Now, one possibility.
Can I just stop you there? So
Of
you
course.
would require a competency, a second evaluation, in any case, if the judge had ordered a competency evaluation for rights to, or ability to stand trial, then you would say there needs to be a second competency evaluation before you can proceed with a self-representation request. Are you aware of any state that has made that a mandated two competency evaluations, or one that looks at both aspects?
Can I answer the question, Your Honor?
Certainly.
So the answer is yes, although I found it too late to cite to this court. And I'll tell you, Connecticut has held exactly this. Now, evaluations, I don't know. I mean, because I can imagine a world where a district judge would look at somebody and say, I know they're competent to stand trial under that extremely low standard. I don't see any indicia that this person's not competent to stand trial. So you may or may not have that first evaluation. But is there a second determination that has to be made in order for somebody to represent themselves? And the answer to your question is yes, that if there are indicia that a person might not have the capacity to represent themselves, then yes, that judge needs to make that finding. And if there is any question, then just like with competency to stand trial, then that judge should take steps to make sure the person is competent to represent themselves.
So there are three tiers: competency to stand trial, ability to waive under Ferretta standard, and then an ability to actually proceed with the trial in a competent fashion.
Yes.
And you're saying the state, or the court here made steps 1 and 2, but didn't proceed to 3.
That's right. And really, those first two are mostly the same. The problem here is that the district court and the Court of Appeals collapsed all three of them into the same. And I'm saying under Indiana v. Edwards, that third one should be a separate one.
Only if the state determines that.
Uh,
To establish.
That will be a
fair standard.
threshold. I mean, it goes back to Justice Steele's question. I don't know. I suppose if you said, no, we're not going to take that invitation, that leaves open a question, right, for the U.S. Supreme Court someday.
You're asking us to go one step past Indiana. Indiana said the Constitution does not prohibit states, and you're asking us to go one step past it and say the Constitution requires states.
I'm saying Indiana Edwards opened up this gray area that wasn't there before.
But you're asking for a rule that says states are required to take this extra step.
I'm
Whereas-
not necessarily asking this court for a rule that says states are required to do that. I'm asking this court to require it.
Well, that is the state requiring it, isn't it? If this court issues a ruling saying it's required.
No,
then-
this court under its supervisor authority can do that. Or this court under its own authority can do that. To say, we think it's important enough that criminal cases are tested by meaningful adversarial testing, and we don't believe that's
So
the case.
your argument is not that the Constitution requires this. You're just making a policy-based persuasive argument to us to implement it as a prudent policy.
That
Is that
Indiana
right?
v. Edwards opens up this gray area, and I'm asking you to set policies for what to do with people in those gray areas.
As a feature of Kansas common law. Okay.
Or this court's inherent authority.
Could you this is kind of expanding on Judge Huff's inquiry. Unable to do basic tasks and self-representation is kind of is what you're asking the district court to look at. And describe to me how that would, what is a basic task that goes beyond competency and the ability to waive? What are we looking for that doesn't interfere with your right to self-representation?
Yeah.
Tell me if the district court is charged with that, what are we going to tell them to do?
Sure. So, first of all, I acknowledge that even in Indiana v. Edwards, parties were asking the U.S. Supreme Court to say, can you tell us more what this looks like? And I think the United States Supreme Court said, no, we're really going to, this is so fact intensive that we're really going to have to rely on trial judges to help us make these decisions. And I acknowledge, I'm sure that this like standard review would be abuse of that discretion if we're talking about this later. One thing might be communicative ability.
Right, speak the language.
Yeah.
But
literacy.
But you have to be probably that's part of the competency equations. I'm just wondering what goes beyond some of this stuff.
Memory. Can I remember, and like if a judge tells me something, do I have the memory to sort of be able to retain that long enough to do something with it, which is different than do I have enough memory to help my attorney with that, right? I think that standard is different. So I don't have great answers for you because the United States Supreme Court didn't give you great answers, but we have a number of district judges, former district judges on this panel, and I think you've been in situations where you're like, this person shouldn't be representing themselves. And the United States Supreme Court recognizes that states are not required under, at least Ferretta, to allow persons to represent themselves when it will result in a situation like Indiana v. Edwards maybe, where there's no meaningful adversarial testing because of that person's mental disease or impairment.
Do we have any further questions?
Thank you, Your Honor.
Counsel.
May it please the court, I'm Kerwin Spencer, County Attorney for Sumner County on behalf of the state of Kansas. To deal with the Edwards issue, just head note number 11 about the severe mental illness. It says the United States Constitution permits judges to take realistic account of the particular defendant's mental capacities by asking whether a defendant who seeks to conduct his own defense at trial is mentally competent to do so. That is to say, the United States Constitution permits states to insist upon representation by counsel for those competent enough to stand trial under Dusky, but who still suffer from, I'm underlining the word, severe mental illness to the point where they are not competent to conduct trial proceedings by themselves. Mr. Hodgkinson could not remember if the word severe was in there or not, hence I looked it up here. The KSA 223216 requires the filing of a written motion to suppress evidence illegally seized prior to trial. The motion shall be made before trial unless the defendant was not aware of the grounds for the motion, but the court in its discretion may entertain the motion at the trial. Here the defendant seems to be trying to litigate a suppression motion for the first time on appeal. This is similar to the case of State v. Stevens at 285 Kansas 307 at 326, wherein the defendant sought to challenge a confession to a DUI case on appeal by claiming his Miranda rights had been violated. The Supreme Court declined to consider that issue for the first time on appeal. Similarly here, whether there was a legitimate issue on suppression of the marijuana in her house or the cocaine in her pocket is not properly an issue before the court to resolve at this time. The issue to be cited here includes which party has the burden of proof on the underlying primary issue, which is whether the defendant had a constitutional right to self-representation, and whether she knowingly waived her right to be represented by counsel. The Feretta case is the case, obviously, where the U.S. Supreme Court ruled that a competent individual has that right to self-representation. That there must be a knowing and intelligent waiver of a right to be represented by an attorney. The defendant must be informed of the dangers of self-representation so that the record will establish that she knows what she is doing so that her choice is made with eyes wide open. Now, there's no real issue that she was not competent to stand trial here. The evaluator determined that Ms. Burden has no significant impairment that is psychiatric in nature. She does understand the nature and purpose of the criminal proceedings against her. Ms. Burden answered the questions calmly and with clarity. There were no areas of impairment noted during this examination. That's page 10 of volume 2.
You would concede, though, that there's nothing in the record definitively declaring Ms. Burden's competency under the heightened Indiana v. Edwards standard.
Well, there's certainly nothing. The heightened Indiana v. standard, that would be, as a preliminary to that, there had to have been a showing that
No, I'm just asking that you agree that there's nothing in the record that where there's a definitive finding that under that heightened standard.
Well, I think that when the evaluator says there were no areas of impairment noted during the
That was
evaluation,
for competency to stand trial, right?
if a person has no areas of impairment, that would support not only competency to stand
Yeah,
trial,
you're
but
arguing
any higher standard.
You're arguing, it seems to me, that the evidence that is in the record is certainly sufficient, perhaps even overwhelming, to satisfy the Indiana v. Edwards standard. That's your
Exactly.
argument. My question is, there's nothing, that finding wasn't ever made. So we would have to make it for the first time on appeal, correct?
Well, I think it's kind of presumed that every person who is competent has that underlying.
Well, let me approach it a different way. I understand the defendant to make the argument that Indiana v. Edwards simply says that there's no constitutional impediment to a state imposing this higher burden. And then the defendant takes the next step and says to this court, as a matter of prudence, we ask you to impose this burden just so that we can be sure that we have a functioning adversarial process. And why shouldn't we do that?
Okay, there's viewing the record in terms of how she functioned. She raised an objection to a photograph being admitted, and the judge overruled the objection, but first we had to have an argument about she'd never actually seen the piece of paper that was a photograph. It had been only provided to her in a disc for her to look at on a computer. And the judge overruled that argument. But that's the type of thing that shows that she actually functioned in a manner.
So you
that
seem
is-
quite confident that she can clear the Indiana v. Edwards heightened standard. I guess
Yes.
this is the last time I'll ask it. What's so bad about having a hearing and having a judge actually make that finding?
So are you wanting to do that in every single case where a person needs a competency evaluation, or only those cases where there's some evidence of severe mental illness, which of course there is no evidence of severe mental illness in our case. So we might maybe need to evaluate in hindsight how well she performed. She effectively had a defense. The defense was
I
successful.
think the defendant is asking for this process to be in place anytime a defendant insists on self-representation, just as a prophylactic protection.
Well, we already have the guidance of Ferretta that talks about there has to be a knowing and voluntary waiver with eyes wide open. So amongst the other things that the trial judge did is he said, you're not going to have the advantage of specialized knowledge of an attorney to assist you in how to pick a jury or how to file know what to evaluate in deciding whether or not to file a suppression motion. And she acknowledged, I understand, I'm waiving that
I was
right.
going to follow up on Justice Stiegel's question. Can that be a part of the waiver process when you waive your right to a jury trial? That almost an implied capability of self-representation by going through the steps of what it takes to engage in self-representation. Can we kind of assume once that thorough waiver is made that might be implied that there's
Yes, because the court had to have made a decision that she, in fact, knowingly waived those rights. And making that decision of knowingly waiving those rights is somewhat a higher threshold than merely being competent to stand trial.
Would that be your position here, that would be at least maybe satisfy that
Yes.
that requirement of?
Yes, that along with the fact that Ferretta included the determination that the right of self-representation is not a license to abuse or the dignity of the courtroom, neither is it a license not to comply with the relevant rules of procedural and substantive law. Thus, whatever else may or may not be open to him on appeal, a defendant who elects to represent himself cannot thereafter complain that the quality of his own defense amounted to a denial of effective assistance of counsel. So that we already have the guidance of Ferretta. So the fact that in hindsight, maybe the suppression motion should have been filed is covered by Ferretta, as this court can't overrule Ferretta, but we should consider the guidance of Ferretta in dealing with those issues. And hence, are we going to second guess each decision that was made by a person who's representing themselves at trial, or are we going to follow Ferretta that says, well, self-representation means that you can't turn around later and claim ineffective assistance of counsel? Ferretta had a high school education and did not want to be represented by a public defender. In our case, the defendant had a high school education. More than that, she had a Bachelor of Arts degree in elementary education, and she had like 23 hours towards a Bachelor of Arts degree. She had an associate's degree, if I misspoke. She had an associate's degree in elementary education, and 23 to 26 hours, as she testified, towards a bachelor's degree in psychology. So, I mean, she's a well-educated individual who, that's exactly the type of person that we deal with in Ferretta, is having the right to represent themselves and effectively make their own defense for all those reasons covered in both Ferretta and the Illinois case. And Edwards v. Illinois did not say that the state has to deny even a severely mentally ill person the right to self-representation. It really says the state can. And in this case, the state did not deprive defendant of the right to self-representation. If the court would have ignored Ferretta and said, no, I'm not going to let you represent yourself, then we would have had the burden of showing that she, in fact, was severely mentally ill to the degree that she could not effectively function as her own attorney. That is a burden that, because the way the judges decided the case, we don't have here. I mean, she's, and frankly, I'm glad we're on this side rather than trying to say that Ferretta wasn't respected under these circumstances where we have a person who's got an associate's degree. So,
Excuse me, counsel.
Yes.
I want to try to synthesize some things I think I heard from both counsel this morning. And if I've got it wrong, correct me.
okay.
If someone says, I don't want a lawyer, I want to represent myself, it sounds like it's being argued that that in turn triggers some sort of inquiry by the court to do these basic legal tasks. And then it sounds like by your reference to Edwards, note 11, that requires some sort of a psychological evaluation that the judge typically would not be capable of performing. Is that how you understand things? That's not your position,
Well,
but is that how you understand the argument?
Well, I would understand that argument if, in fact, we wanted to say that Ferretta wasn't going to be always controlling here. Edwards doesn't say that we have to say that Ferretta's not always controlling. But if the effect is that you already have a competency evaluation and already have psychological testimony, why do we have to do that again where we've got an evaluator who says that she has no disability that's psychological in nature?
Well, you're veering into the facts of the case, and I want to keep this isolated. Is it your reading of Edwards, note 11, that there has to be some sort of a psychological evaluation on this issue?
No. It only has to be a psychological issue on that issue if the state wants to deny the defendant's ability to represent themselves.
If we accepted the invitation of the Supreme Court to do this sort of thing, is it your position that there has to be some sort of a psychological evaluation?
No. There has to be a good enough record that the trial court can determine that there was a knowing waiver of all the advantages of having an attorney represent. And if in the process of that query, mental issues come up, then the court should go ahead and go the second step and have a mental evaluation.
All right, thank you.
Okay. The other things to cover is that she promulgated an effective defense at trial of raising a doubt as to whether or not her daughter actually got the marijuana pipe or part of the marijuana pipe from her house as opposed to her former husband's house. She was found not guilty after trial in reference to that. She was formulated a defense that it should be legal to possess marijuana and cocaine because those are natural products, and she's got a certification as a personal trainer, and so she knows from experience that natural products are better for you than other types of drugs. And the problem is with that was that's not a defense in Kansas. but she had a strategy there, basically asking for jury nullification, and that didn't happen. And so she was found guilty of the cocaine that was in her pocket and the marijuana that was in her house, but it's not because she didn't try to raise what she thought would be an effective defense. And she did things like objected on hearsay grounds to what the officer repeated as the daughter's testimony or daughter's statement. And so we made a record of the fact the daughter was going to testify, and then the judge overruled the question. So if you look at the record here, she did make some effective decisions as an attorney, and there's no evidence of any severe mental illness that would raise the possibility of, under the Illinois case, stepping in and saying she had to have an attorney. Under Feretta, she was exactly the type of person that was entitled to represent herself, and she did, and now can't complain that there was anything ineffective about her representation.
Thank you, counsel.
Thank you.
What are you asking us to do?
I'm asking you to affirm this decision. And, I mean, she's already off probation. The case is already over with completely, except for this. Thank you.
Thank you, counsel.
Your Honor, I don't have anything in response to my colleague's argument.
What, as I understood, at least part of that, it was essentially a harmlessness argument, that even if we would impose some duty or say that Judge Mott should have gone another step, that if you look at the record here, she was competent to some extent. I mean, obviously she may not have made all the arguments that we would say could have been made. What's your response to that?
So, I mean, I suppose, I haven't thought through whether it could be harmless, but if it could be, again, you have to look at this whole record and decide whether or not the record supports this idea that she could not have been found incompetent to represent herself based on the entirety of the record. And I mean, the fact that somebody is able to sort of do something with regard to one count, but then admit on the stand essentially the other counts, I don't think that solves that problem. So we would argue that the record that we have, that you look at it, that you wouldn't sort of be able to make that finding, and what that finding would be, I suppose, depends on whether or not this is actually a constitutional question or not. But on either one, that there has to be some finding that there's no either reasonable or real possibility or probability that the outcome of a competency hearing would have been different. And I don't think the record that there's enough in this record for you to say that.
Why does that have to be a harmlessness argument? Why can't it be similar to a fair trial in a high publicity, high profile case where we look at the jury selection process and see what difficulties there were in getting a jury passed? It's not a harmlessness test. That's actually looking at indicia of prejudice. So it seems to me that you might look at those instances and the fact that she won an acquittal on one count to be supportive of the district court's decision that she knowingly and voluntarily waived her right to counsel.
Wait, Your Honor, the last point, we're not arguing that she didn't voluntarily waive her right to counsel.
I understand that. I understand
that's
you're trying to expand on that, and I'm not sure the one consideration doesn't fall under that same umbrella, but I still get to the same point of why can't we look at the trial not from a harmlessness standpoint, but to see whether there's any additional evidence of a lack of competence.
Okay. I don't think I'm not asking or saying that this court's prohibited from looking at what she did at the trial. In fact, I want you to look at what she did at the trial and what she did not do at the trial. And that would be a part of and would be part of this district court's decision if this court remands for a competency decision to say, what were the indicia before trial and even at trial. I think a district court, just like with competency to stand trial, right? Even in the middle of a trial, a district court might say, all of a sudden, I'm really not comfortable with where we're at, and I'm going to stop proceedings until we go forward. So I'm not saying that. I don't know if it matters what you call it, Your Honor. as far as whether it's harmlessness or prejudice. My understanding is, I mean, if you say that in a situation where there are indicia that the district judge in this case should have had and done a separate analysis of whether Ms. Burden was competent to represent herself, whether there's some, it would be our position that the record supports that there could have been a different outcome in this case.
And I need to clarify, when you were up before, I understood you to concede essentially that you're not making a constitutional claim here. You're making a claim based on Indiana v. Edwards and the need for this protection as a matter of state policy.
I have not necessarily, I'm saying we don't know if it's a constitutional question or not, so I've not advanced that argument. That's certainly true, Your Honor.
Okay, so, but as you stand here now, you can't point this court to any specific constitutional violation that you're claiming.
Not based on the current state of the law.
Okay, you're asking for a remand to avail ourselves of what Indiana v. Edwards permits but doesn't require.
That for the gray area that Indiana v. Edwards opens up, yes.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
I thank both counsel for your arguments this morning. Court will take this matter under advisement.